What's up, everybody? Welcome back into an episode of The Lawyer You Know. And today we're jumping back into the Adelson case as trial is approaching starting next week. Donna Adelson wants to be able to call her daughter, Wendy Adelson, to the stand to help in her defense and be able to ask her questions. Will Wendy Adelson do it? And if she doesn't want to, will the judge force her to? And if he doesn't force her to, will it become an appellate issue? Plus, another motion filed by the defense. We're going to go through all that today and more, and of course, answer your questions. Let's get to it. All right. So the first document we are going to pull up here is, in fact, a document filed by Wendy Adelson where we discuss whether or not she is going to help mom. What's your guys' guess? Is Wendy Adelson going to help Donna Adelson out here? Is she going to throw her a bone? A lot of people think that everything the Adelsons have been caught up in is because of Wendy Adelson, right? Dan Markell, her ex-husband, the father of her children, is at the center of this entire conspiracy and story and tragedy that we've been covering for years and years and years. And we know Wendy Adelson has testified at multiple trials. Multiple trials. Will she testify again at this one? The answer is most likely, but who will she testify for? And who will she be beneficial for? That's the question. Let's take a look at this motion filed by Wendy Adelson. Non-party Wendy Adelson's motion for permission to place a statement on the record and to quash the defense subpoena. Defense would be her mom, Donna Adelson. Non-party Wendy Adelson is the daughter of defendant Donna Adelson and is expected to be one of the first witnesses called by the state in Donna Adelson's trial. Both the state and the defendant issued trial subpoenas to Wendy Adelson. By law, the state subpoena confers immunity on Wendy Adelson, but the defendant's subpoena does not. So this is going to be the first part of our discussion point here. The state can force Wendy Adelson to take the stand. And Wendy Adelson, as we know, has not been charged with anything. But she says, I'll plead the fifth. And Wendy Adelson says, I'm not going to testify because I might incriminate myself, which some people will side-eye at. But you know what the state can do, just like we saw in the YSL trial? They can say, no. Not going to work here. We're going to force you to testify because we're going to give you immunity, and we cannot prosecute you for anything that you say on the stand when we call you as a witness. Power. That is the definition of power, folks. The state attorney has all the power. The prosecutors, the government, law enforcement, they hold the power. So the defense is like, hey, we'd like to call her too if that's possible. And Wendy Adelson's like, nope, I want to quash your subpoena, which means squash it. Get it out of here. I'm not going to testify. You want to know why? Because you can't offer me immunity. So whatever questions you ask me, I plan on pleading the fifth. And in Florida and most jurisdictions, you can't put somebody on the stand just to plead the fifth in a criminal trial like this as a witness. So how is that fair? How is it fair that the state can call a witness that the defense also wants to call, but the defense, because they're not the state attorney's office, because they don't control who gets indicted and who doesn't, can't call her? Seems like there should be some scenario where you could submit questions. Defense attorneys hate doing that. But at least it's better than not calling her at all. Maybe the judge could take a look at him. Maybe the state would offer immunity for the questions that you have. We'll talk about whether those options exist in something like this. But it's very clear from this motion that Wendy Adelson has no interest in helping Donna Adelson. It's kind of similar to Charlie Adelson saying, hey, Ma, I don't want you using my lawyer. Even though you're very close and you have somewhat of a mother-son relationship with him, talking about Dan Rashbaum, I didn't waive. You can't use him. He can't cross me. It's going to hurt your trial if you go forward with the lawyer that you want. And it was very clear Donna Adelson wanted Dan Rashbaum. So both of her kids, or 2 out of 3, right? The other one we're not going to talk about, but 2 out of 3 of her kids potentially have an opportunity to help her. Seems like nobody wants to help mom at this point. By law, the state subpoena, accordingly, Wendy Adelson respectfully moves for permission to place a statement on the record regarding the state of Florida's trial subpoena. And these are Exhibit 1. And to quash the trial subpoena issued by the defendant. Exhibit 2. In support of the motion, Wendy Adelson states as follows. Donna Adelson is charged by indictment with first-degree M alleging she participated in a conspiracy to kill Dan Markell, Wendy Adelson's ex-husband, on July 18th, 2014. So it's just about almost exactly 11 years. Other alleged members of the conspiracy were charged and convicted, including Catherine McBanoa, the Second Circuit Court case. In the McBanoa trial, both the state and the defendant subpoenaed Wendy Adelson to testify. This is not the first issue or first time we've heard of this issue. In response, Wendy Adelson filed a motion, like the instant motion, to place the statement on the record and to quash the defense subpoena. Thus, the two trial subpoenas by each party in this case present the same issue the court dealt with in a previous trial. The state subpoena affords Wendy Adelson use and derivative use immunity for her testimony in an instance where she would otherwise invoke her Fifth Amendment right. So the way it works is, hey, we're going to call you. No, I'm going to plead the Fifth. No, you can't because we're giving you immunity. While the defense subpoena provides no such protections, meaning if you call me, I have to plead the Fifth because whatever I say can and will be used against me. Unlike the state, they can no longer use that against me. Doesn't mean they can never prosecute her, just can't use what she testifies about when she's under their subpoena in this trial. There's always it depends if she lies, if she conspires, if she commits fraud or, perjury on the stand. There's all those, other things in there. But generally speaking, in the McBanoa trial, the court quashed the defense subpoena and granted Wendy Adelson's attorney an opportunity to place a statement on the record. And they attached part of the transcript. We request this court grant the same relief in this case. Let's read the footnote here. In the related hearing before the court in the McBanoa trial, McBanoa's counsel argued it would be reversible error for McBanoa's cross-examination to be limited, because it's not just when the defense calls her, but also when they're cross-examining Wendy Adelson. To be limited because the state can tailor their direct examination to prohibit McBanoa from going into areas that could potentially be relevant, based on dicta by the First District Court of Appeal in McBanoa's appeal of the prior protective order prohibiting the deposition of Wendy Adelson. In that the opinion, the first DCA did acknowledge that McBanoa would be given little latitude in her cross-examination of Adelson because her questions would be limited to the narrow categories of information the state elicits at trial. The state is going to completely control what Wendy Adelson does, but sometimes more importantly, does not testify to at trial. However, the first DCA did not grant McBanoa's requested relief in that appeal and recognized that when the Fifth Amendment guarantee collides with the Sixth Amendment in circumstances such as these, the Sixth Amendment right must yield because to require one to incriminate themselves in order to afford help to another would be both unwise and unrealistic. So what does that mean? That means right now we've got two rights that are butting heads. We've got Wendy Adelson's Fifth Amendment right not to incriminate herself, but we also have Donna Adelson's Sixth Amendment right to a fair trial to confront these witnesses against her. And when they butt heads, what is more powerful? A person's Fifth Amendment right not to incriminate themselves is more powerful than another defendant's Sixth Amendment right to a fair trial. Now, I get it. I don't disagree with that. But it is frustrating and seems like we should be able to come up with a better way to handle this. We're going to read the appellate decision. It's only a 4-page decision in the McBanoa situation to help us understand if this is going to be a big appellate issue for Donna Adelson. Not yet, though. And just this past month, the first DCA again addressed the same arguments by McBanoa. The first DCA found no error in the court's handling of Wendy Adelson's trial testimony, favorably cited Wendy Adelson's counsel's statement on the record, and concluded the trial court properly ruled that she could not be called as a defense witness. Therefore, there's no reason to depart from the procedure employed by the court in the McBanoa trial. In the McBanoa trial, the court scheduled a hearing relating to this requested relief just prior to Wendy Adelson's testimony. Wendy Adelson respectfully requests this court to set a similar hearing on this motion outside the presence of the jury prior to her testimony or at such time determined appropriate by the court. Here's the memorandum of law. The court should allow Wendy Adelson's attorney to place a statement on the record regarding the state subpoena. Wendy Adelson will testify pursuant to the state subpoena, but without such a subpoena, she would invoke her rights under the Fifth Amendment to the United States Constitution and Article 1, Section 9 of the Florida Constitution. So why is this important? Well, the court needs to know without a doubt that she would invoke her Fifth Amendment right in order for all of this rigmarole to take place. As a result, Wendy Adelson requests that once the state calls her as a witness, her counsel should be allowed to place on the record the statement outside the presence of the jury that 1, Wendy Adelson intends to invoke her Fifth Amendment right and Section 9 rights. 2, Wendy Adelson's testimony is entitled to use and derivative use immunity pursuant to Florida Statute 914-04 and Jenny v. State. And 3, use and derivative use immunity extends to any testimony given during Donna Adelson's cross-examination of Wendy Adelson. Very similar to what happened in the McManawin trial. Given the state's theory of the case, there's no question that Wendy Adelson has a real and substantial interest in asserting her rights against compelled testimony. Meaning, is it realistic that Wendy Adelson would incriminate herself? Why does she have to worry about that? Is that fair, or is she just trying to get out of testifying? Well, no. There's basically a big Adelson conspiracy. That's the state's theory. And the state's theory is Wendy Adelson knew or should have known. It should have been pretty obvious. And everybody was doing this for Wendy Adelson. Pretty easy to connect those dots that something Wendy Adelson could say could be used against her and could potentially be incriminating. So I think that's a fair statement. No person who has been duly served with subpoena or subpoena ducis tecum shall be excused from attending and testifying before any court having felony trial jurisdiction, grand jury, or state attorney upon investigation, proceeding, or trial for a violation of any of the criminal statutes of this state upon the ground for the reason that the testimony required of that person may tend to convict him or her of a crime or to subject him or her to a penalty of forfeiture. The court should quash the defense subpoena. Although Donna Adelson will have a full and fair opportunity to cross-examine Wendy Adelson at trial, will she? Will it be full and fair? I don't think it will be. And despite knowing that she would otherwise assert her Fifth Amendment rights, Donna Adelson's counsel issued the defense subpoena. Unlike the state subpoena, the defense subpoena confers no such immunity. The self-executing feature of Section 914-04 discussed in Jenny is limited to cases where the state subpoena a witness to testify before the state attorney, grand jury, or before a court having a felony conviction jurisdiction. It cannot be invoked by the defendant to immunize a witness, obviously, right? We defense attorneys and defendants do not have that power. The law is well settled. The purpose of the Florida Statute 914-04 is to aid the state. A defendant cannot immunize a witness in order to secure the witness's compulsory testimony. Simply put, the defense has no ability to confer immunity upon a witness under Florida Statute 914-04, even where the witness is likely to provide exculpatory and reliable evidence. If called as a defense witness, Wendy Adelson would invoke her Fifth Amendment rights to every relevant defense question. Therefore, any testimony Wendy Adelson provides beyond the matter covered under the state subpoena would result in a potential waiver of her Fifth Amendment rights, which she does not intend to do. So right here, it's very, whoops. Let me get, what should we use here? Highlighter. Not interested in helping you, Mom. Because every relevant defense question, I'm going to plead the Fifth. Florida law is equally clear that it would be improper for a party to call a witness for that witness to invoke her rights before the jury, right? We've been over this a million times in a million different cases. Florida 3rd DCA in 2020, calling a witness to invoke the Fifth Amendment protection in front of the jury creates a dramatic moment causing irreparable damage and injury in the eyes of the jury. Thus, there is no proper purpose for the defense subpoena, and it should therefore be quashed to ensure the integrity of the trial process and to protect Wendy Adelson from unnecessary harassment and abuse. Under these circumstances, the defense subpoena should be quashed. And they cite a case where it held that the trial court erred in refusing to quash the defendant's trial court subpoena. Okay. So that is Wendy's motion to quash, and very clearly her stating, sorry, not sorry, Mom. I am not going to help you. I am not going to answer these questions. What could be done? What does a court think could be done? This just does not seem fair. Let's take a look at the Florida 1st DCA decision that just came down July 2nd, 2025 in Catherine McManawin, who is a co-conspirator with Charlie Adelson so far and allegedly Donna Adelson. We will see. The same issue happened. Catherine McManawin eventually lost her trial and they appealed it up. So we get to see exactly what happened here. Before we read it, let's hit some questions. Larry, if I were Donna, I'd roll over on Wendy like a rotisserie chicken. Defense, let's talk plea deal. So we don't know if that plea deal was actually offered or not, right? Maybe it was offered. It would make sense if it was offered. Something similar was offered to McManawin. Donna says no. Wendy files this motion. How does that make Donna feel? But I've got thoughts on what would actually happen if the judge didn't quash this or Wendy actually did testify for the defense. I don't think it's what a lot of people think, so I'm gonna hold on that. Do you think Wendy will be indicted after this trial, regardless of whether she testifies? Will the verdict for Donna factor into that decision? I don't know that the verdict of Donna will factor into that decision, and I don't know if she'll be indicted. it would follow and track based on how they've done everything in this case, right? One at a time, taking years to get down the road, but eventually trying to get full justice for the Markel family. So I totally understand that. I just don't know if they have enough on Wendy at this point. I think some people may assume, some people may say the story fits. It only makes sense if Wendy was involved. But I think they would have gone for Wendy earlier if they really had enough testimony or if they really had enough evidence against her. But you could say maybe they felt like they needed her testimony to convict everybody else, so they did it this way. It's a very unusual way they've been going about this. Donna, welcome to the membership crew, and MCKT, thank you for gifting 5 memberships. Let's get to this appellate court decision. Following a second jury trial, appellant Catherine McManawah appeals her convictions for first-degree conspiracy, solicitation, etc., in the shooting death of Florida State University law professor Dan Markel in July of 2014. For the reasons stated below, we affirm McManawah's conviction, which means McManawah loses. McManawah makes 3 arguments on appeal. First, she argues that the trial court erred by not evaluating the Fifth Amendment assertions made by Markel's ex-wife, Wendy Adelson, during her deposition. Before the first trial, which ended in a mistrial, McManawah deposed Adelson. A transcript of the deposition is not part of the record, but the trial court reviewed the transcript, evaluated Adelson's Fifth Amendment assertions, and concluded that Adelson's counsel made a good faith effort to separate out questions that he could advise her to answer from those he was concerned were suspect. So she tried to answer some, which is good. Following the invocation of Fifth Amendment privilege, the trial court then determines whether the responses to the questions posed will potentially implicate the party asserting the privilege. Although McManawah takes issue with the trial court's conclusion, without the deposition transcript, the record is inadequate to demonstrate reversible error. It is well established that in appellate proceedings, the decision of a trial court has the presumption of correctness and the burden is on the appellant to demonstrate error. So the lack of a trial transcript or a proper substitute results in a record that is inadequate to demonstrate reversible error and requires affirmance. So this is when we talk about that you're limited in what you can argue and appeal. It's what happened at the trial court, what's actually on the record, what is the evidence in that case. You can't be bringing stuff up that you didn't enter into the record. Second, McManawah argues that the trial court erred in granting Adelson's motion for a protective order to quash the subpoena for her appearance at the deposition. This argument is moot. After the court dismissed McManawah's petition for writ of cert to quash the order, the trial court granted her motion for reconsideration and Adelson was deposed. An issue is moot when the controversy has been so fully resolved that a judicial determination can have no effect. Third, McManawah argues that the trial court erred in not granting the state's motion in limine to prohibit McManawah from calling any witnesses, including Adelson, for the purposes of the witness invoking the Fifth Amendment. The state requested that certain procedures be followed, including the trial court make a pretrial ruling on what questions McManawah could ask Adelson as a defense witness. So here's what I want to point out. And I like to see this stuff by prosecutors, okay? Because if you're a good lawyer, you want things done the right way, you want things done the fair way, okay? And like I said earlier, this just feels unfair, fundamentally unfair. I don't like things that are unfair. I'm a big fan of justice, right? And a lot of lawyers are. So when we have a situation like this and it's like, man, it just doesn't feel right that we're able to call a witness, ask them whatever we want, they can't. So let's try to find a way that we can make this happen. And so what did the state try to request or propose in this case? The state requested certain procedures be followed, including the trial court make a pretrial ruling on what questions McManawah could ask Adelson as a defense witness. I don't know exactly how this all played out because I didn't see it. But if I was the defense, I would say, here are the 20 questions we want to ask her, or here are the 3 topics we want to go into, or here are the exact 5 questions I want to ask her. That's it. And I think the state may have been open to that. And if that would have been allowed, at least they would have been able to ask her certain questions. But sometimes defense lawyers like to do something a little different. Number one, they don't like to give an inch. So they like to say, we're not going to do that. We're not going to tell you our questions beforehand, which is a legitimate gripe. But when you look at the case law and you know your argument's a losing one, you have to figure out what is the best way to represent your client. And sometimes it's giving and telling the state what you want to ask in order to be able to ask any questions at all. But some defense attorneys don't want to do that for a number of reasons, one of which is protect the issue for appeal. Because if they agree to submit these questions, you're pretty much waiving that issue for appeal because you got to ask the questions you want. Now, if they say you can ask these 6 and not these 4, well, then you preserve the issue on appeal for those 4 questions. So that's why sometimes defense attorneys don't want to do things like this. And from my perspective, I get it. I get it. And you've got to understand that Every defense lawyer they have a lot of information coming in, and they have a lot of information that they have to analyze, and they have to make tough decisions and quick decisions. Alan Jackson's talked about it a lot. And from my perspective, he does a good job of explaining how you take that information, you make a decision, and you have to live with it. Now, he's uber confident, potentially one of the most confident lawyers that we've heard, very secure, self-assured, right? And when you talk about the fact that you've got to live with these decisions, whether you win or lose, that's something you have to take on as a lawyer, and that's something Magbanawah's lawyers did. Because Magbanawah did not join in the state's motion, she cannot now complain that the trial court erred in not granting the motion. The general rule on appeal is to review the proceedings of an inferior court is that a party to the cause may appeal only from a decision in some respect adverse to him. Additionally, during the second trial, after Adelson's counsel advised that Adelson would unequivocally invoke her Fifth Amendment right to any question asked of her unless she was under a state subpoena, the trial court properly ruled that she could not be called as a defense witness. This is the exact issue before the court in Donna Adelson's case that Donna Adelson's arguing right now. So I expect the decision to be exactly the same, and I expect it not to be a real appellate issue. Do they want to appeal it? Fine. It's going to be a loser just like this one was. That's my guess. They cite a case that holds that neither the state nor the defense may call a witness that the party knows will invoke the Fifth Amendment and refuse to testify. Based on the record before us, Magbanawah has not demonstrated prejudicial error. Prejudicial error means an error in the trial court that harmfully affected the judgment or sentence, right? This is how difficult an appeal is. You have to prove that it's actually prejudicial error in most cases. In preparation for the second trial, Magbanawah had the benefit of not just Adelson's deposition testimony, but also her testimony from the first trial. I still don't think that's enough if the state gets to ask whatever they want and the defense doesn't. But the defense also didn't take the opportunity to try and, work through something and be creative. And even though Adelson could invoke her Fifth Amendment privilege in response to any questions posed in the deposition, the very invocation of the privilege by Adelson in response to specific questions may inform Magbanawah's trial preparation. During the second trial, Magbanawah was able to thoroughly cross-examine Adelson, and Adelson answered all questions asked by Magbanawah. Now, I don't know that they would agree that they got to thoroughly cross-examine her. I've done a lot of talking today. A lot of fun stuff coming next week, even though I'm going to be in trial. We have recorded some stuff that's very different that I can't wait to see what you guys think about it. And give me your honest opinion because it was kind of cool. And some of you guys asking me questions gave me this idea and sending me in some cases of things happening to lawyers and all this talk about AI and all that. Some cool stuff coming next week. So hopefully you guys hang with me and are able to watch it, even though it's not going to be, newsworthy on whatever event happens next week because I'm going to be in trial. So it's going to be hard for me to kind of jump on and do that stuff and keep up, as they say. Also, this trial is starting, but they're going to take a couple days to pick the jury. I don't think we're going to get opening statements till Thursday or Friday at the earliest in this case. And then either over the weekend or maybe Friday night or something, I'll be able to dig into opening statements. And then we're full go ahead starting the week of the 25th with the Adelson recaps. Okay. So overarching theme there is, in fact, that Wendy Adelson, not likely to help Donna Adelson, and she's probably going to win just like she did in the last trial, and it's probably not going to be an appellate issue. Okay. Will your trial be videoed? No, it will not. It is not being live streamed. It's a civil case. It's unusual that those happen. And, if somebody wants to request videos for it, they can. I'm never going to do that because none of my clients would really ever want to do that, having their business aired out there. Peter is admitting he's really AI. Just wait. Maybe there's two of me. Right? The real one of me is at the office right now. The AI version of me is here doing this YouTube video. You'll never know, right? Oh, I didn't answer this part. So this is kind of the overarching theme of this. Another reason why maybe Magbanawah, maybe Adelson's team didn't push harder for this, especially Donna Adelson's team, is what is Wendy Adelson really going to do to help them? What is she going to do to build their case? And is she going to be helpful? Because her testimony has been consistent that she was not involved. She did not know. They didn't tell her what was going on. She thought this was just a hit. She didn't think or know her family had anything to do with this. She has kind of backed off and not had a lot of communication. She was not involved in any of the code language texts. She is not involved in any of the recorded conversations. So she has isolated herself, however you want to look at it, to not be a part of what this conspiracy tends to be. So how much help is she really going to be to the defense if she was going to testify? And if she's going to testify and throw herself on the sword for Donna Adelson, Donna Adelson might as well take the immunity deal and testify against Wendy, and Wendy go to jail and Donna be out. To do it this way, to have her fall on the sword and also potentially Donna get convicted, makes no sense. I sent you an email yesterday concerning legal help. When you have time, would you or please take a look? Sandy, I will try to take a look at that. If you sent it to lawyeryouknow@gmail.com, John, take a look and please forward that along to me. I wish we could watch the trial you're doing. I do too. I think it'd be really fun. This one is going to be a banger. There's so much going on in this one that's unbelievable. Some of the judicial rulings in this case, hammering the other side, I was like, whoa. It surprised me even. It surprised me. It's going to be a fun one. I'm really looking forward to it. And I haven't tried a case in 2025 yet. So I'm excited to get back in the courtroom here. I'm supposed to have another one in September, so it might be back-to-back trials here. We'll see. That'll be stressful, but fun. Okay. Here we go. Defendant's motion to suppress. Henry violation. I haven't even read this yet. Somebody sent this to me. This is one of the newer motions. I think it was filed on the 13th. Donna Adelson, by and through undersigned counsel pursuant to Article 1, Section 12 of the Florida Constitution, 6th and 14th Amendment to the United States Constitution, move this court to, I think, suppress statements she allegedly made to Drina Bernhardt, and in support thereof states as follows. On November 15, 23, Mrs. Adelson was indicted for first-degree M, conspiracy to commit first-degree M, solicitation to commit first-degree M. On April 7th, the state disclosed the existence of 2 jailhouse informants, including Drina Bernhardt. Although recordings of her interviews with law enforcement were provided, the underside was unable to depose Ms. Bernhardt until August 11, 25. Because Bernhardt had violated her probation and pretrial release conditions and could not be located. That's not great. Bernhardt was arrested on her warrants on August 5th, and the undersigned promptly scheduled her deposition. So in case this is untimely, the judge is not going to hold it against the defense because obviously unforeseen circumstances outside their control. Then on August 12th, the state disclosed another witness, Mickey Easterwood, aka Mickey Lang, who was also incarcerated with Adelson and Bernhardt and provided a recorded interview, which took place on August 11th with investigator Jason Newland and special agent Patrick Sanford. During this interview, among other statements, Ms. Eastwood disclosed that rather than Bernhardt merely listening to Adelson make statements about her case, Bernhardt also asked Adelson questions. As a result, Bernhardt, acting as an agent of the state, Ms. Adelson moves to suppress any statements Adelson made after December 20th, 2024. Bernhardt testified she met Adelson in the annex. According to jail records, Adelson was initially moved to the annex in August of 24. Bernhardt was arrested for a violation of probation on a new charge on September 18th. On December 5th, Bernhardt was initially interviewed by Detective Joshua Turner of the Leon County Sheriff's Office. During this interview, Turner provided Bernhardt with his contact information. Subsequent to the interview, Bernhardt wrote a letter to Turner, which he received through the interoffice mail. A copy of the letter is attached and incorporated as Exhibit A. Is that attached here? We're going to read. Oh, of course. We don't get to read it. We don't get to read it. Okay. So that was Exhibit A. On December 18th, Turner again interviewed Bernhardt. During his interview, Bernhardt provided LCSO with information about human trafficking case and Adelson's case. After the December 18th interview, Turner contacted investigator Jason Newland. On December 20th, Bernhardt was brought into the state attorney's office to be interviewed. During the interview, Bernhardt confirmed her current plea offer was 5 to 6 years. During her deposition, Bernhardt conceded she was both a violent felony offender and special concern and qualified for sentencing as a prison release offender. So you better believe that when somebody like this testifies at a criminal trial, and we've had this happen as well, we make sure to hammer home just how unreliable they are, and the jury knows. The statements Bernhardt made are addressed in previously filed July 29, 25 motion to eliminate, and transcripts of those interviews have previously been provided to the court. Bernhardt told the state on December 20th that Adelson called Bernhardt her jail daughter. During the recorded interviews, law enforcement told Bernhardt not to ask Adelson questions, just to listen to whatever Adelson said about the case. So not to ask Adelson questions. Specifically, Newland stated, "So you cannot be an agent for us. I can't send you in there to ask her any questions." And he would be right. And the fact that they have this already, and she knew she was not supposed to ask questions, maybe this one has some legs. We'll see. Listen, if she has a casual conversation with you, there's nothing stopping you from having a conversation with her. So the question might be before the judge, was it just a casual conversation or was it a question and answer? Don't make things weird. Don't initiate any of these conversations. Newland continued stating, this is one of the biggest things that is to come out of this meeting with us is don't make it awkward, but definitely do not go back there on our behalf thinking you need to get us more information. Bernhardt testified that she provided written documents to Turner of what Adelson asked/instructed Bernhardt to say when testifying on 10 different occasions. Okay. So Adelson was telling her what to say. She later testified this happened more than 10 times. Turner testified in his deposition this took place once or twice. During her August 11th, 25 deposition, Bernhardt initially claimed she did not ask Adelson any questions, but later said that she did ask Adelson questions. The fact that Bernhardt engaged in conversation rather than just acting as a listening post with Adelson is corroborated by a subsequent identified witness, Mickey Easterwood, entered the chat. Mickey Easterwood informed law enforcement Bernhardt questioned and manipulated Adelson. That's not good. During the August 11, 25 interview, Easterwood said that it was very obvious that she was trying to get information out of Donna. Instead of acting as a listening post, Bernhardt was not merely a passive listener. Rather, she continued to engage in conversations with Adelson. Statements purportedly made by Adelson after December 20th, 2025 were a product of these conversations. The state's desire to elicit additional statements from Adelson resulted in 3 additional recorded interviews with Bernhardt. Discussions of law. In Henry, the Supreme Court held that law enforcement cannot deliberately elicit conversations with a defendant in order to elicit incriminating information. Obviously, right? We got rights. The Sixth Amendment prohibits law enforcement officers from deliberately eliciting statements from a defendant after the right to counsel is attached. The deliberately elicited standard is clearly satisfied when the police directly interrogate or question a defendant, but it also may be satisfied by less direct types of questioning. According to jail records, Easterwood was incarcerated from July 25 of 24 to August 23rd of 24, and again on November 20th until February 10th, 25. The other side seeks to suppress the statements purportedly made by Adelson to Bernhardt, which Bernhardt revealed during these interviews. They cite a case that says even though the defendant initiated the meeting, the defendant's right to counsel was violated where an undercover co-defendant met with and actively obtained incriminating statements from him. Completely makes sense, right? And when it comes to the generally bad guy or generally bad gal rule in this case, we still have to protect those generally bad people. Donna Adelson, whether we like it or not, is presumed innocent. So excited I'm not in lecture and I finally get to catch her live. Went back for neurobiology, and your videos get me through commuting to school every day. Claire, kudos to you. Much smarter than I. And I'm glad we can provide a little time passing with our reading here. Corey, perhaps an unpopular opinion, admittedly, but the incredulous nature of these potential witnesses seems to dilute the stronger evidence against Donna. No, thank you, Laurie. No. Yeah, as defense lawyers, sometimes you love when they call a jailhouse snitch, Sometimes you love when they call them because the jury's not going to like these people. Jury's going to be like, yeah, this person will say anything in order to get their sentence lessened. And even though they didn't agree to anything before their testimony, they all know the prosecutor's going to help them out, put in a good word, right? I totally get what you're saying. And you really only use, and this is the tough job of a prosecutor. We talked about it during Karen Reed. We talked about it during the Charlie Adelson trial. We talked about it in a lot of different trials. Murdaugh. What evidence do you present? Just because you have this much evidence, you've got to pick the best evidence to streamline it and keep it simple, stupid, right? The KISS method when you're trying these cases. As a civil plaintiff's lawyer, I do it too. I cut out so many things that I've got to explain to my client, like, yeah, that might help us a little bit, but if it takes 2 hours, the jury might get bored. Then our case gets longer. We've really got to pare it down as much as possible. Prosecutors have to do the same thing. So what will they use? Passivity on the part of law enforcement is the critical factor in the analysis. A knowing exploitation by the state of an opportunity to confront the accused without counsel being present is as much a breach of the state's obligation not to circumvent the right to the assistance of counsel as is the intentional creation of such an opportunity. Here's what else I'll say. This is impossible for us to know what the outcome is going to be because it's all going to flip on, was it passive? Was it intentional? Was she interrogating her and questioning her? Was it a simple conversation where Donna was doing most of the talking? We don't know what was actually said. So it's hard for me to really say what I think will happen here. How long will this trial be? Including jury selection, I think they expect it to be about 3 weeks, 3 to 4 weeks, I think, total. But it depends on, how long they deliberate, how long jury selection takes, things like that. Donna is definitely taking the stand, it sounds like. In Saunders, the court held that applying the framework set forth in Rawling v. Brown, the first district decision in Zekine, establishes that the proper inquiry into determining whether a defendant's statements to a jailmate informant violates a defendant's Sixth Amendment rights is the degree of law enforcement involvement at the time the statements were made. In Z, The defendant made incriminating statements to his cellmate, who then reported the statements to law enforcement and worked with law enforcement to obtain more information. The court affirmed that any statements made by the defendant to his cellmate after the date the cellmate began working with law enforcement were obtained in violation of his Sixth Amendment rights and were not admissible, but that any statements made before the date were admissible. See also Peoples v. State. Although the defendant's jailmate approached police on his own accord, recorded statements violated the defendant's Sixth Amendment rights because the state granted the cellmate immunity and otherwise arranged for and conducted the clandestine monitoring and taping. Where law enforcement intentionally creates a situation likely to induce a defendant to make incriminating statements without the assistance of counsel, statement made by the defendant should be suppressed. There's a lot of judicial discretion in this. This is especially so when the informant is not merely a passive listener, but rather is actively engaging in the defendant's conversation, questioning the defendant, and then reporting back to law enforcement, if that's what happened, right? Stated differently, a Sixth Amendment violation is only shown where the defendant establishes that the informant and the authorities had a pre-existing plan to obtain a confession. Law enforcement violated Ms. Adelson's Sixth Amendment rights. Any statements which the state can establish to have been made prior to December 20th of 24 may be admissible. However, the state sent Bernhard back into Leon County Detention Center with the specific intent to elicit information from Adelson. Although the state may have told Bernhard just to listen, they also said to not make it awkward and that Bernhard could continue to engage in conversation with Adelson. The plan was for Bernhard to continue to engage in conversations with Adelson in the hope she made more statements. Bernhard did what she believed she had to do so it would not be awkward. By sending Bernhard back into the jail, and I guess they're saying, the law enforcement saying don't make it awkward, was too much involvement. That's why she started asking questions, et cetera, et cetera. By sending Bernhard back into the jail with the stated purpose of obtaining additional information from Adelson, the state authorized Bernhard's actions. By further allowing Bernhard to benefit from her continued conversations with Adelson, her probation was reinstated instead of the 15-year prison release, reoffender sentence, or the purported 5 to 6 year offer. The state incentivized Bernhard continued actions on the state's behalf. Sounds eerily similar to the case that they cited. As a Sixth Amendment violation is shown where a defendant establishes the informant and authorizes had a pre-existing plan for the informant to obtain a confession, a Sixth Amendment violation is established in this case for any statements made by Adelson after December 20th, 2024. Based on the foregoing, the state violated Ms. Adelson's Sixth Amendment right, and this court should suppress any statements Bernhard claims Ms. Adelson made after December 20th, which is when she met with law enforcement. Sounds like a pretty good motion. I don't know whether they're going to win or not because I don't know what the context or the content of the conversation was. And I think it's going to just come down to judicial discretion. But I think there's definitely some legs to this motion. I really do. Is it all coming in, Peter? So some of it's definitely coming in. All of it, I don't know. It depends on a lot of the context that I don't know from looking at this motion because a lot of it's blacked out. The exhibits are blacked out. Oh my gosh, did anybody see the Wheel of Fortune with Donna? Yes, I did. Somebody sent that to me on Instagram. It was something else. Somebody said Wheel of Fortune has been circulating. This is the first time I had seen it. It did remind me a little of Sarah Boone, right? She was on Price is Right or something, right? I mean, it's wild to think those throwbacks that happen. So this trial is starting next week. Let me know what you guys think about it. Let me know what you think about these motions and about Wendy not really being willing to help Donna. Make sure you hit that like button, please. Make sure you're subscribed. Send me whatever crazy stuff happens in this trial or anything else that you guys are following. I appreciate you always being here, showing up, hanging out, asking great questions. But until next time, we are out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, X, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast featuring new episodes every week. And if you have a case that you want to personally talk to us about in your life, if it's a personal injury case, wrongful death, catastrophic injury, car accident, truck accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.